Hello everyone, this is Brian Ka with another video to help you pass the California baby bar exam. So there were several people that reached out and commented on my videos saying that they were getting a lot of value from watching these videos, and I am so glad that I can help people with passing this difficult but doable baby bar exam. And since I know what you're going through, and I've also failed this test once 10 years ago, so I know what it's like to be on the other side of the aisle, the failure side. And I also understand what it's like to be on the passing side of this baby bar exam. So, using all those experiences, I am here to guide you and help you and tell you things that you probably won't hear from your law schools. So I am so thankful and grateful that some of you guys are learning and are able to apply my train of thinking when it comes to these MBE questions. So I know that in the previous video, I've gone through one of the community property essays, and I am going to do another community property essay today. If you watch this video and feel like I'm missing something, that is a very good thing. It means that you have all the law memorized and you're able to point out some things that maybe you thought that I could have done better. And I invite you to think that way because although I've been working very hard at perfecting writing these essay questions for community property, I may not be perfect. Obviously, no one's perfect. And you might have some legal theories and you may want to include that in your own writing. And I think that's fantastic. In the end, this is a video to help you see how another person writes community property essays. And by watching it, I want you to see the strengths, I want you to see the weaknesses, and eventually use this information the way another person writes to better your own writing so that in the end you can pass the subject of community property when it comes down to it on your bar exam. I don't know if you've heard this already or not, but for the upcoming changes for the bar exam, I've heard that they're getting rid of community property and including family law. Now, I've heard that from two bar tutors that I saw on YouTube. So, and I didn't read the Supreme Court case regarding this change. So, I am not 100% sure if this is going to happen. But if you're taking the bar exam in the next 2 years, possibly three, I don't think this will be an issue for you. But keep in mind that for those of you who will be taking the bar exam in 3, 4, 5 years, just know that community property won't be tested, but rather they're going to test you on family law. But regardless, since this subject is still being tested for the upcoming bar exam and probably a couple more years after it, we're going to try to knock out all these community property questions that were administered in the past. So here we are with another question. This is a February 2014 community property essay. So like the previous one that I did with you guys, I'm gonna try my best to hash out every issue and try to write as much as I can. But again, it won't be perfect because there's always room for improvement. But at the same time, I feel like I have a pretty good grip of the subject now and essay writing. So I hope that whatever I'm doing here will help you and make you a better writer. So here we are. Question two. Hank and Wendy are residents of California. Hank is a teacher and Wendy is an accountant. In 2008, Hank and Wendy married. After their wedding, Wendy's mother deeded them a house as joint tenants. They moved into the house and used their earnings to furnish it in a lavish style, including an antique mirror in the entryway. One day, Hank gave the mirror to a friend who had admired it on a visit to the house. In 2012, Wendy purchased a small office building where she established her own accounting practice. She paid for the building with funds saved from her earnings during her marriage and took title in her name alone. In 2013, Hank and Wendy separated. Hank told Wendy that the house was henceforth her separate property, and she said, okay. After the separation, Wendy's income from the accounting practice tripled, and she remodeled the office building with her increased earnings. Without Hank's knowledge, she then sold the building to Bob, who did not know that she was married. In 2014, Wendy initiated dissolution proceedings. Number one, what are Wendy's rights, if any, as to the antique mirror? Discuss. Number two, what are Hank's and Wendy's rights, if any, as to the following: the house, the accounting practice, and the office building? So, right off the bat, this question seems a little bit difficult just because you'll probably be strained for time, yet they're asking you to divide four type of assets, right? So as I've discussed in the previous community property essay video, I've told you that for each community property essay, you should start out the same way. And that is, let me try to remember the good old community property intro essay. So you always want to start out by saying that California is a community property state, right? And then you want to say, you want to define what community property is, and then you want to define what separate property is. So all property acquired during the MEC, which is marital economic community, is considered community property, right? Now we have to define separate property. All property acquired before or after marriage is separate property. Additionally, all property acquired during marriage by devised bequest or inheritance is separate property. Now, after defining community property, separate property, you want to talk about how to characterize assets, right? So you want to say something like courts characterize property by three following ways. Number one, statutory presumptions. Number two, actions taken by the parties. Number three, tracing to the source of the assets, right? And then you probably want to talk about quasi community property. You want to say all property acquired outside of California during marriage, which would have been community property had the spouses been domiciled in California, are considered quasi community property. And then you can probably mention something like marriage ends when there is intent not to resume, and a separate physical separation. And the way I write this changes every time, but the basis of it will never change, like such as defining community property, defining separate property, and then talk about how courts may characterize assets using three ways. And then I talk about quasi community property, and then I talk about okay, if here marriage ends when there's intent not to resume marriage, any physical. And then I talk about what a permanent separation means legally, which requires a physical separation plus intent not to resume marriage. So I think I am pretty good with that, the first intro. And again, like I've said before, for every community property essay, you want to start out the same way. And that's sort of a good thing because you don't have to like worry about writing anything different. But if you haven't memorized what you need to write for your intro for every community property essay, then this will be difficult. So I know that I stress memorizing a lot in law school, but after failing so many times and after doing first year like three times, failing the baby bar ones, after so many failures, I came to a conclusion that the best way to learn is to understand because you can't really memorize something that you don't understand. So you have to try to understand the legal concepts, and after that just try to memorize everything as much as you can. All right, so let's talk about the mirror. Probably. So when it comes to property acquired during marriage, what is it? It is that all property acquired during marriage is community property, right? So what happened in this is, moreover, a spouse seeking characterization of asset will be able to rebut this presumption by proving that the property can be traced to a spouse's separate property asset, right? So in this fact pattern, they moved into the house and used their earnings to furnish it in a lavish style, including an antique mirror in the entryway. So in this case, both Hank and Wendy moved into the house and used their earnings to purchase an antique mirror in the entryway, right? Since this mirror was purchased during the marital economic community, and the and chasing the source of the asset showed that it was purchased from the earnings of both Hank and Wendy. This antique mirror presumption that it was community property will not be rebutted, right? So so it will remain as community property. So what happened here? Hank gave the mirror to a friend who had admired it on a visit to the house. So what's the issue here? The issue is I'm blanking out again. Equal, not equal protection, equal management and control. That would be the next issue. Either spouse, I'm just writing the rule now for the issue of equal management and control, may contract debts or purchase property without the approval of the other spouse. However, this is there are some limitations to this rule. First, a spouse cannot encumber real property without consent or joinder by the other spouse. Second, a spouse cannot sell personal property such as clothing without the other spouse's consent. Thirdly, a spouse cannot um, make inter vivos gift to a third party without consent by the other spouse, right? And then I would say that Hank will argue that that him giving away the antique mirror was not a gift, so he did not violate the doctrine of equal management and control. However, Wendy will argue that Hank gave away the mirror without receiving any consideration in exchange, which violates the equal management and control doctrine, since the facts indicate that Hank did not receive a consideration for the antique mirror and gave it away as a gift. Wendy is right. Therefore, he did not give away the. Therefore, Wendy will be able to restore the community by setting aside the gift. And then I will talk about this position. If Wendy is able to get the antique mirror back, she will be able to restore the community. But since she has the right to half of the antique mirror, if in case she is unable to restore the community by setting aside the gift, she will most courts will most likely award her the value of half of the antique mirror from other assets that belongs to Hank. So I guess I just ended it like that. And obviously, these answers can be improved, but I am trying my best right now to, you know, use the doctrines and write to the best of my abilities. But obviously, it's different when you're sitting in front of a camera talking and trying to write. I think that I could probably do better when when I'm not focused on trying to talk about this and just focus on writing. But nonetheless, this is the best I can do right now. And again, if you feel like I'm missing something, or if you feel like there is a part that could be improved, I think that's a great thing that you're able to see what I am missing here and basically improve your writing so you can write so much better than I can. So that's good. So moving on, we have to talk about the house. House. So the house here is interesting because you know um, as mentioned above earlier, all property acquired during marriage through bequest, devise, or inheritance is separate property of the spouse receiving it, right? In this case, Wendy's mother, Wendy inherited a house from her mother. So the house will be presumed to be Wendy's separate property, right? And then I will talk about anti Lucas provisions. Um, Under Lucas, let's see. Separate property contributions to the community was considered a gift. at death or dissolution. However, Antiochus statute allowed the contributing spouse of separate property to receive a reimbursement, right? Upon death, however, Lucas will still apply and separate property contribution will still be considered a gift. Moreover, under Lucas and anti-Lucas, joint property will jointly titled will be presumed to be community property. In this case, though Wendy received the house as inheritance, her mother intended the house to remain as joint tenants, and she deeded the house this way. So under Lucas, this since the house was deeded as joint tenants, it will be presumed to be community property, right? And then later on, they say in 2013, Hank and Wendy separated. Hank told Wendy that the house was henceforth her separate property, and she said okay. So transmutation is an issue here. What's the rule? Transmutation occurs when there is a writing signed by the adversely affected party and an express declaration stating that the transmutation is to occur from SP to CP or CP to SP and analyze. When Hank and Wendy separated in 2013, Hank told Wendy that the house was her separate property. There is no indication that this was put into writing. Moreover, the adversely affected party in this case, who is Hank, didn't sign the writing, nor did it include an express declaration that the transmutation will occur. Therefore, there was no valid transmutation disposition. Due to anti-Lucas provision, the jointly deeded house will be presumed to be community property. Since transmutation was not valid, it did not change its characteristics from CP to SP. Therefore, the house will be divided evenly at divorce, and each spouse will receive 50% of the house. All right, so that was complicated by the fact that Lucas provision was involved, and I think that maybe I might have gotten the Lucas provision wrong. I will double check, but one thing I'm sure of is that for Lucas, there is a presumption that jointly titled property is presumed to be community property. That's correct, 100%. So since the house was deeded, although it was an inheritance, which makes the house separate property, since it was deeded, and that was the intent of the mother who deeded the house as joint tenants, then there is a presumption that the house was community property, not separate property. Now, we talked about transmutation. When you talk about transmutation, you need three things: writing, signed by a person whose rights are adversely being affected, and then express declaration saying that the characteristics of the property is being changed. But since none of those were present, there was no transmutation in this case. So it didn't change from CP to separate Wendy's property. So it would remain as community property and will be divisible at divorce evenly, half, 50% each for each spouse. I think that was pretty thorough. So let's move on and do the accounting. Oh, this is taking a toll. It's a lot of work, but let me try my best to finish this out. So, accounting practice. So, all property acquired during marriage is community property, right? Now, what happened? I guess we should talk about through tracing to the source of the asset. If the property was acquired with a spouse's separate property, this would rebut the community property presumption and make the property a spouse's separate property, right? Um, if we assume that the accounting practice was established with Wendy's separate, then the increase of the value of that separate property due to community property would be calculated using the Pereira and Van Camp formula. So I guess we just quickly talk about it, even though there's a chance that, or it's probably likely that this is not a separate property accounting practice, but if we assume that it was, if we assume that it was separate property and it increased in value, we use Pereira. The formula is investment, original investment plus rate of return. Usually 10% times original times years of marriage. This would be separate property. Community property will be the rest. Per is used when the increase in value of separate property was due to community efforts. Van Camp. Van Camp formula is um, salary times years years of marriage. I'm having a blank moment again. Salary times rate of return times should be community property. From this, family expenses will be subtracted and the rest will belong to the separate spouse. Van Camp is used when the the increase in value of separate property was attributable favorable to market conditions. Since it is very likely, however, that uh, the accounting practice was established using funds from Wendy's earnings during marriage, however, the courts will not have to use these formulas since it was a community property asset. It will eventually be divided in half and distributed it evenly between the spouses. All right, so we're almost. Since no, that's the we don't have to talk about that. So we said that the lastly, well, the thing is, we have to talk about income after divorce, right? So date of dissolution. Sorry, I'm going back and forth. Date of permanent separation. Permanent occurs when there is a physical separation combined with intent not to resume marriage. In 2000, facts show that Hank and Wendy separated. It doesn't tell us whether they physically separated, but since Hank told Wendy that the house was hers, it shows intent that they did not want to resume marriage. If court rules that this is the date of permanent separation, all earnings after this date would belong to Wendy since it was her accounting practice. if the court rules that 2014 is when permanent separation occurred, then all earnings before 2014 will be community property. The characterization of the business itself will still remain as community property. So, date of permanent separation was important because all earnings after the date of separation will be separate property, and all earnings prior to the date of separation will be community property. So, since the income from the accounting practice tripled after separation, that triple income would belong to Wendy, but the business itself will still be characterized as Hank and Wendy's. As for the profits, increase in profits, it will depend on whether the court will rule that the separation occurred in 2013 or 2014. If it occurred in 2013, all profits from the accounting practice until that time will be CP, and if all right. So I guess data permanent separation was important. This is a lot of writing. We still got some left. That was kind of repetitive, but since I'm short on time, I'm not gonna go back. All right, so Wendy purchased a small office building in 2012 and paid for the building with funds saved from her earnings during her marriage. Since all property acquired during marriage is CP, this office building is presumed to be her CP. Wendy will argue that since the title was solely in her name, it was her separate property. However, Hank will argue that title is not controlling when the source of the asset could be traced to the earnings from during the marriage. Hank has a better argument here, and that even though she titled the office building to herself, that is not dispositive, and the building will remain as CP of the spouses. Um, so she remodeled the building. So we have, after marriage, SB improvement to CP, right? When a spouse improves CP with his or her separate party earnings, she will be able to get reimbursement for the increase in value of the property or cost of improvements. Here, since Wendy's income was used to remodel the office building, she will be able to seek reimbursement, whichever one is greater. Characteristics of the office building will still remain as CP, right? Bob's purchase. Actually, equal management and control. As discussed earlier, spouses cannot dispose of real property without other spouses' joinder or consent. Here, Wendy sold the building to Bob without Hank's knowledge. If Bob was a um, bona fide purchaser, good faith purchaser, Bob Hank will have 1 year to void the contract. If Bob was not a BFP, Bob Hank will be able to void the contract even after 1 year. Hmm. If Hank is able to void the contract, he will be able to set aside the sale and bring the office building back to the community, and he will receive 1/2 value of the office building. Um, then I guess breach of fiduciary. Additionally, Hank may argue that spouses owe each other highest duty and good faith. And when they breach this fiduciary duty, when she went behind his back and sold the property without his consent or knowledge. If Cora buys Hank's argument, it is possible that it will award Hank higher portion of the value of the building. Meaning he will be able to receive more than 50% of the value. All right, I was kind of losing it there because there's so much to write. But I think that's it. Let's see. I could have done better, but did my best. Mirror, equal management, and control, disposition house, anti-Lucas provision, transmutation, disposition, accounting practice, Praraf, and camp, date of separation. Okay, office building. Wendy purchased a small office building, and then SP improvement to CP, equal management control, breach of fiduciary duty. All right, so this may not be like an 80 essay, but I feel like this is a passing essay, probably like a 70 for sure. I think it's a 70. So remember the goal is to pass. The goal is not to score the highest, and the goal especially is not to become the model answer. Even though that would be an honor, but my goal is definitely not to be a model answer, but instead just finish out the test and pass. So hopefully you learned something from watching me try to do this question. And again, it may not be the perfect answer, but I tried my best so it can be a passing answer. And If you have any questions regarding this video, feel free to leave a comment and I'll try to get back to you as soon as I can. Thanks for watching.